Hello, my name is Amy Verdun, and I'm here with Professor Martha O'Brien from the University of Victoria to talk about the legal foundations of the European Union. Martha, the EU's legal system is based on foundational treaties concluded between member states, the EU's so-called primary law. What are the main treaties currently in force, and how do they structure the EU's legal system?
The main treaties now in force are the Treaty on European Union, or TEU, and the Treaty on the Functioning of the European Union, or TFEU. These are both multi-party international conventions or treaties, and are also constituting the primary law of the European Union. These treaties function somewhat like a constitution for a state, and contain the fundamental provisions establishing the European Union, setting out its goals and principles, its institutions and their powers and competences, and the relationship between the EU and its member states and citizens. It also underscores the centrality of the rule of law and democratic principles in EU governance. Some of the provisions date from the earliest years of the European Coal and Steel Community and the European Economic Community in the 1950s, and some were new with the Lisbon Treaty, and even more recently with the accession of Croatia to the EU in 2013.
Based on the treaties, the EU produces its own legislation, the so-called secondary law. What types of secondary law can be distinguished?
There are three main types of secondary law that are enforceable within the EU. These are the regulations, directives, and decisions. Regulations are directly applicable in the member state from the time they come into force. That is to say, when they are adopted and have been published in the official journal of the EU. By saying that they are directly applicable, we mean that they become part of the law of each of the member states, and the member state governments must conform their administrations so that they carry out the regulations. And the courts of the member states must also recognize and apply the law contained in the regulation, as if it had been adopted by their own government. People and organizations are also able to enforce their rights under the regulations in their national courts as if they had been passed by their national governments. Directives are different from regulations in that they require all member states to pass national laws through their national legislatures to revise their national laws to conform to the standards that the directives set out. This is a process called harmonization or approximation of laws, usually within a time frame of 2 years. Failure to harmonize national law with the directive constitutes a breach of the treaty obligations of the member state, and the Commission can commence a process culminating with a judgment of the Court of Justice determining that the member state is in breach of its treaty obligations. If it continues to fail to implement the directive in accordance with its terms, then the Commission can take the member state back to the Court of Justice and ask for a fine or a penalty, sometimes going into the millions of euros. And a national of a member state that has failed to properly implement a directive, if they've suffered loss, can actually sue the member state for damages for failure to implement the directive. So you can see that there are enforcement mechanisms built into the system. The third kind of mandatory or enforceable binding EU law are decisions. These are addressed to one or more member states or individuals or corporations, anyone that is a subject of European law. There are various processes by which the EU legislature, the Council, Commission, Parliament pass or adopt decisions. And in some cases, the Commission receives a delegated authority to take decisions on behalf of the Union without the participation of the Council or the Parliament. And perhaps the best known decisions that the Commission takes are the ones in the field of competition law. For example, the Commission may take a corporation to court on and make a decision against them that essentially says you've abused your dominant position, you've otherwise engaged in anti-competitive behavior in the European Union, and your fine will be this, and you have to divest yourself of certain of your assets in order to comply with EU competition laws. So those are quite famous. Google, Microsoft, for example, have been fined. I think Google's was something like 2.8 billion euros for anti-competitive behavior. The European Union also adopts its treaties or international agreements with other third parties through decisions. So, for example, the Canada-EU trade agreement, the CETA, was adopted by a decision of the Council. And the Council acts on behalf of the EU to adopt by decision the CETA, and it becomes binding on the European Union, its institutions, and its member states, at least to the extent that the member states are not required to ratify. There are also two types of non-binding legislation set out in the treaties. These are recommendations and opinions. Their main role is to serve as aids to interpretation and application of the binding EU laws.
So what differentiates the EU's legal order both from that of a state like Canada on the one hand, and from that of more conventional international organization on the other hand?
In fact, the EU's legal and constitutional framework is not very different from that of a federal state such as Canada, and its internal legal order actually has quite a lot of similarities to Canada's. If we analogize the EU to the federal Canadian government and the member states to provinces, we see a division of powers in the Canadian Constitution and in the EU treaties that is different in its specifics, but not in its nature, with a Supreme Court in the EU, the Court of Justice, and in Canada, the Supreme Court of Canada, that has the power to rule on which powers can be exercised by which level of government. The differences are more due to the fact that Canada inherited its legal systems from the UK and France many decades ago, in 1867, and over time has established its constitutional order and conventions. In the EU, each member state had a long legal tradition and national culture that varied considerably from the other member states, so that harmonizing them and bringing them together into one uniform legal system has been difficult and non-linear, I would say. It's hard for the EU to have consistently moved towards a union of states and peoples as it states its goals are. And it has not been a very long time, really not until the late 50s that the process began. However, there are also a lot of similarities between the Canadian system or any federal system and the EU. A judgment of the Supreme Court of Canada, for example, is binding throughout Canada, just as a judgment of the Court of Justice is binding throughout the European Union. A law enacted by the federal parliament immediately has effect throughout Canada in all the provinces and territories, just as a regulation enacted by the EU legislature becomes immediately applicable throughout the European Union. The differences between the EU and the ordinary international organizations, such as the UN, include the ability of the European Union legislature to adopt laws that are integrated into the national legal systems of the member states, the control exerted by the EU courts over the other EU institutions, and the binding effect of judgments on the EU courts on member states and their citizens. So by comparison, if you took the International Court of Justice in The Hague, it can rule on disputes between UN members, but its rulings can be ignored by those parties to the dispute. Each country that belongs to the UN retains its full sovereign power to choose to abide by UN resolutions or not to abide by them, to respect the standards of human rights of the UN or to flout them, with nothing but the international community's condemnation to deter a country from its actions.
So what are the main powers of the Court of Justice of the European Union? Can you describe in broad strokes how the court has influenced legal integration in the European Union?
The Court of Justice ensures, under Article 19 of the Treaty on European Union, that in the interpretation and application of the treaties, the law is observed. That is, that the EU is governed by law and not by rich or powerful or influential persons or corporations or political party. That's what we mean by the rule of law. The Court's early recognition of the principles of direct effect and supremacy had a profound influence on the evolution of the European Union's legal system. It's safe to say that if the Court had not recognized these principles early in the development of the European Union, the EU might have remained a conventional international organization with little impetus to develop an ever closer union with a uniform supranational legal system. The decisions of the court are enforceable, and failure to follow an order of the court can result in fines and penalties imposed on member state governments, individuals, and corporations. For example, in October 2021, the court imposed a penalty of 1 million euros per day on the Polish government for failure to implement the court's order that Poland suspend its laws that restrict the judicial independence of its country's judges.
So the powers of the Court of Justice and the principle of supremacy in EU law over member state law have sometimes been contested, for instance, by the German and Polish constitutional courts. You've already spoken about that briefly. Can you talk about these conflicts and how significant they are?
In fact, almost if not every member state has at some stage contested or challenged the doctrine of supremacy of EU law. And it has been a process by which every member state came to understand in its own legal system how European Union law had primacy over its own law. The German Constitutional Court has more recently, in various contexts, questioned the ultimate authority of the Court of Justice to determine the field of application of European Union law, which has sometimes led to reconsiderations or narrowing of an EU policy, but not to any real concern that Germany might leave the EU or face serious sanctions. In the case of Poland, the dispute is more ideological and confrontational, with the Polish Constitutional Court ruling that provisions of the Treaty on European Union are incompatible with the Polish Constitution. This is a very significant dispute, politically but not legally. Supremacy of EU law and the binding nature of EU law on the Polish Constitutional Court and on the Polish court system is not in dispute as a matter of EU law. It would be a problem for Poland alone to choose either to accept supremacy or ultimately withdraw from the EU if it weren't for the war in Ukraine currently, in which Poland is hugely significant as a haven for refugees, as a member of NATO, and as an anti-Russian bulwark of the European Union. So the political problem right now, of course, is punishing Poland under EU law is extremely uncomfortable when it is playing a role that is very important to the European Union's future expansion.
Thank you very much for this conversation. Appreciate the time.
You're very welcome.